I'll check. I'll check. Yes. नहीं किसी को So we'll just wait for 2 minutes.
Yes, yes. Take your time.
Madam, Abhida Madam will be joining. The president
Yeah.
of this function will be joining.
Yes.
Thank you, sir. Dear participants, we just wait for 2 minutes. Our president of the function will be joining, and we start. Due to some technical issues, Madam is joining in 2 minutes.
स्टार्ट करेंगे
करने पड़ी हाँ नहीं वो ज्वाइन आई
बाकी लोग ज्वाइन हो गए यस ज्वाइन हो गए
अभिषेक कर सकते हैं हाँ
शुरू करें कि मेरा प्रेजेंटेशन
पहले वो लोग शुरू करेंगे फिर आपका आना
Salim sir, shall we start?
Yes, ma'am, we shall start with. Yes, ma'am.
Yeah, okay.
Hello.
Hello, yes, madam.
Yeah, can you hear me? Yes.
Yes, ma'am.
Madam, shall we start?
Yes.
Okay. The consumer movement marks 15th March with World Consumer Rights Day every year as a means of raising global awareness about consumer rights. Celebrating the day is a chance to demand that the rights of all consumers are respected and protected, and to protest against market abuses and social injustices which undermine those rights. World Consumer Day Rights is globally recognized with support from the United Nations and other international actors. Consumers International members help to select the campaign topic each year to help mobilize global action on pressing issues impacting consumers. This year, the theme focuses on a just transition to sustainable lifestyles. It underscores the urgent need for a fair and inclusive shift to sustainable ways of living. In this backdrop, on the occasion of World Consumer Rights Day, the Consumer Protection Empowerment Center of MC Societies, AKK New Law Academy, in association with Consumer Advocacy Group, organizes international conference on new facets on consumer protection challenges and the way forward. I am pleased to mention that today's event is the 69th event of the Consumer Advocacy Group towards the protection and empowerment of the consumers. A very good morning to our esteemed guests and distinguished participants. I, Dr. Jacinta Stephen Baston, on behalf of MCA Society's AKK New Law Academy Pune, extend a very warm welcome to all to the inaugural program of today's online international conference on new facets on consumer protection, challenges, and the way forward. Joining us as chief guest for the inaugural function of the conference is Honorable Justice Makran Karnik, Judge, High Court of Bombay at Goa. The inaugural function of the conference will be presided over by Honorable Mrs. Abida P. Inamdar, President, MNE and RC, and Vice President, MC Society, Pune. We have two international speakers as resource persons for our conference, namely Advocate Carolina Rice Villota, former President FIDA and Member of Parliament, Colombia, South America. And also we have Advocate Chioma Ongen Chia Yuko, Chairperson, FIDA, Abuja Branch, and Principal, Zest Legal Consults, Nigeria, Africa. To invoke the blessings of the Almighty, we shall now commence the program with the holy words from the Quran. I request Ms. Suhana Poshekar to recite the Tilawat-e-Quran. Over to you, Suhana.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم إنا آتيناك الكوثر فصل لربك وانحر إنك شانئك هو الأبتر صدق الله العلي العظيم.
Jacinta ma'am, please unmute yourself. Jacinta ma'am.
What are you?
Thank you very much, Suhana Poshilkar, for the sacrosanct words from the Quran. Now I request Dr. Salim Sheikh, Principal of MC Societies, AKK New Law Academy, to deliver the welcome address and theme presentation of today's international conference. Over to you, sir.
Yes, thank you, madam. A very good morning to one and all, distinguished delegates, esteemed guests, and the participants. It is an honor to address you today on this online platform for the international conference on the new facets on consumer protection, challenges, and the way forward. At the outset, on behalf of Maharashtra Cosmopolitan Education Societies, AKK New Law Academy, and Consumer Advocacy Group, I, Principal Dr. Salim Sheikh, would like to welcome our chief guest, Honorable Justice Sri Makran Karnik Sir, Judge, High Court of Bombay at Goa, to this international conference. Welcome, sir. Honorable Justice has been very kind enough to accept our invitation to grace today's international conference. We are very grateful to His Lordship for his valuable presence. I also welcome the President of today's international conference, Honorable Mrs. Abeda P. Inamdar Madam, President, Maharashtra Medical Education and Research Center, and Vice President, Maharashtra Cosmopolitan Education Society, Pune. I welcome you, Madam. I extend a warm welcome to our distinguished international resource persons, namely Advocate Carolina Rios Vilota, former President, FIDA, and Member of the Parliament, Colombia, South America. I welcome you, Madam. And Advocate Shioma Onyenyar Uka, Chairperson, FIDA Abuja branch and the Principal Just Legal Consults, Nigeria, Africa. I also welcome on behalf of our institution. Thank you so much. As we have the privilege of the presence of our chief guest, Honorable Justice Sri Makran Karnik sir, our international delegates. In this conference, I would like to mention some of the highlights of our college, which is one of the prestigious institutions amongst the law colleges in Pune. Our college, that is the Maharashtra Cosmopolitan Education Societies, AKKNU Law Academy, Pune, was established in 1994. The college is approved by the Bar Council of India and permanently affiliated to Savitribai Phule Pune University. It has been recognized under Section 2F and 12B of the UGC Act 1956. The college has been reaccredited by NAC. The college runs LLB 3-year, BA LLB 5-year, and LLM 2-year courses. In addition, our college was the first one under the Savitribai Phule Pune University for having the recognized PhD Research Center. I take pride in saying that 95% of our faculty are the PhD holders and 75% of the staff are PhD guides. AKKNU Academy, in addition to imparting the legal education to the students, also plays a vital role in catering to the needs of the society by establishing various cells and centers, that is the CPEC. One such consumer protection and empowerment center at our institution. This center has been established for empowering the consumers in protecting their rights, fostering fair market practices by providing information, redressal mechanisms, and promoting awareness about the consumer rights and the responsibilities. Every year, we conduct various awareness programs under this center. This year, on the occasion of celebrating the World Consumer Day, that is today, 15th March, our Consumer Protection and Empowerment Center, in association with the Consumer Advocacy Group, organizes this online international conference on the new facets on consumer protection, challenges, and the way forward. Herein, I would like to mention that Dr. PVVS Murthy is the founder and Dr. Shaista Inanda is the coordinator of Consumer Advocacy Group Maharashtra. Through these conferences, our center of our college and the CAG endeavors to provide opportunity for the participant to share their ideas and the experiences online with their peers expected to join from the different parts of the world. Further, the conference is aiming to converse and exchange the ideas relating to the consumer rights, safety measures adopted to protect consumer rights, and the remedies offered in the laws at the national and international level. I'm glad to mention that around 100 participants have registered and selected once have the opportunity to present their research paper in the technical session of the conference. With these few words, I once again extend a hearty welcome to distinguished delegates, the guests, and the participant to this international conference. And I wish all the participants a fruitful day of deliberations. And I hope this conference it proves to be a memorable experience for everyone. Thank you once again. Thank you.
Thank you very much, sir, for those introductory remarks for today's international conference. Today, we are highly privileged to have with us a legal luminary, yet a very humble personality, Honorable Justice Makran Karnik, Judge, High Court of Bombay and Goa. I request Dr. Swati Shinde to introduce the chief guest of today's international conference, Honorable Justice Makran Karnik, Judge, High Court of Bombay at Goa. Over to you, madam.
Thank you very much, madam. Am I audible, ma'am?
Yes.
Yes, ma'am.
Yes. Very good morning to one and all. It is a privilege to introduce today's chief guest for the online international Justice Sri Makaran Karnik sir, Judge, High Court of Bombay at Goa. Basically, sir is from Nashik, Maharashtra state. Honorable sir has completed LLB degree in the year 1991 from Pune University by securing first class with distinction. Honorable Sir enrolled as an advocate with the Bar Council of Maharashtra and Goa on 22nd July 1991. Since then, practiced at Bombay High Court and appeared in number of civil, criminal, labor, service, and constitutional matters. Further, Sir has engaged as a senior counsel, Group 2, to represent the Government of India and also represented the High Court administration from 14th April 2009 till elevation. Honorable Sir has been appointed as amicus curiae in several matters, and Sir has been elevated as an additional judge, Bombay High Court, on 17th March 2016. Lastly, it has been rightly said by Adam Grant that good leaders build products, great leaders build cultures, good leaders deliver results, great leaders develop people. In the same way, great leaders have values, good leaders are role model at work, and great leaders are role model in life. And Honorable Sir, you are the role model for us. And with these few words, I welcome you, sir, and thank you very much.
Thank you very much, Swati Madam. With great anticipation, I now invite our esteemed Chief Guest, Honorable Justice Makarand Karnik, sir, to grace us with his insightful words. Over to you, sir.
Thank you for the kind words, Dr. Swati Shinde. I'm delighted to be a part of this one-day international conference hosted by your college. The Honorable Mrs. Abeda Inamdar, the resource persons, the learned distinguished Advocate Carolina Rios Villoto, Advocate Chioma Onyevenchu Uko, Dr. Pratap Singh Salunke, the Honorable Dr. P.A. Inamdar, Honorable Abeda Inamdar, Dr. Swati Shinde, Dr. Jacinta Bastian, Dr. Manisha Agrawal, Dr. Bharti Shilke, Dr. Shaista Inamdar. Well, all the participants who are present here in so large numbers, and good morning to one and all. Well, the consumers have an important role in the business system. Consumers are individuals who purchase and use goods and services offered by businesses. Consumer rights must also be protected in order for the business world to progress. Physical trade gave way to e-commerce, which is also known as online commerce, as technology progressed. E-commercial activities have come to the top of the list of cyberspace's most significant and popular activities. Thanks to the e-commerce platform, Indian customers were able to purchase across state boundaries and enjoy the items of their choice. Now, the concerns about the protection of online customers and their interests are developing as the number of e-commerce enterprises grows. Because of the inflexible nature of the law, consumers are frequently left with little options. Data protection problems, jurisdictional issues with dispute resolution, and deceptive advertising are among the issues that e-commerce poses. The development of electronic commerce is putting consumer rights under threat. Customers can anticipate a friendly and inviting environment from online e-commerce, as well as prompt and courteous replies to their inquiries if the company is well established. With the advent of internet commerce, a plethora of legal and consumer challenges have arisen. In India, we are witnessing a confluence of new technology and banking sector liberalization. In this age of fast change, consumers need to be protected, and the law is striving to catch up. Now, what are these historical trends? I would like to just give you some brief background about the historical trends of consumer protection laws in India. Consumer protection laws trace back to 3200 BC in India. At the period, Ethical practices were extremely important. The monarch's primary priority was the well being of their subjects. Rulers of the period were concerned not only with the people's social situations, but also with their economic well being. The authorities had also imposed several trade restrictions in order to safeguard the interest of purchasers. People in ancient India followed Dharma Shastra or Dharma, which contained social standards and customs as well as guiding principles for public relations. Manu mentioned adulteration in products in Manusmriti, stating that, and I quote, one commodity, goods of whatever sort, mingled with another, like kind, shall not be marketed as it is of pure origin, unquote. He also mentioned penalties for unfair trading practices, such as the least severe sentence for adulteration and mutilation for fraud in the sale of counterfeit goods as genuine. He also stated that any deal with a kid, an elderly man, or any other unauthorized individual is void, implying that he was speaking about the competency of the contracting parties at the time. Following procedures, contracts, and other topics in Kautilya's Arthashastra, which was written between 400 and 300 BC. Consumer protection in telecommunications market has always been related to competition, with a focus on supply-side policies to maintain a healthy market. However, in recent years, there has been a growing realization that through demand-side solutions, informed and empowered customers may compel firms to innovate, enhance quality, and compete on price. Consumers benefit from competition not just by making well-informed vendors' decisions, but also by fueling and supporting it. As the use of communication services has grown and converged, the rules that regulate client relationships with communication services have become increasingly important. The Consumer Protection Act of 1986 had a similar lengthy title, but it was over 30 years old and lacked important provisions to address problems that arose in the current technology period. Thus, legislators felt it was necessary to replace the old act with a new one. Parliament enacted the Consumer Protection Bill 2019 on 6th of August 2019. The Act of 2019 has the same goal as the Act of 1986, which was to provide for the timely and effective administration of justice, as well as the prompt resolution of consumer disputes and matters related to consumer disputes. Now I go to the main features of the new Act of 2019, and they are: when developing this Act, lawmakers considered the demands of current customers and included new terminology that was not there in the previous one. For example, in the definition of advertisement, they have included words like any audio, visual publicity, representation, endorsement, pronouncement made by means of light, smoke, gas, print, electronic media, internet or website, and includes any notice, circular, label, wrapper, invoice, or such other document. This means that any person, such as a consumer, can go to court if they are harmed by any kind of misrepresentation. The lawmakers have included new sections in the new Act, such as a language regarding product liability action and a definition of complaint, which states that a complaint is directed at the manufacturer, seller, or service provider, depending on the facts of the case. When crafting this Act, it was borne in mind that if a juvenile purchases a product, he or she has the right to protest to the product or seller. Thus, there is a provision that allows parents or guardians to seek redress on behalf of the minors. A consumer is defined under the Act as someone who buys or sells products or services, including digital things, through a digital or electronic network. The consumer has the right to be protected against the sellers and marketing agencies who offer items or services that are risky or detrimental to the consumer's life or property. Consumers have the right to inquire about the quality of the product being sold, the amount being sold, the standard and purity of the goods in order to avoid unfair trading practices. The consumer has the right to inquire about alternative products or services that have comparable price and or are in competition with this product or service whenever possible. Now, the most important new element in this period is the inclusion of e-commerce within the scope of consumer protection. There are various sections which deal with electronic service providers, e-commerce, and whether or not there are provisions for liability in the event of online fraud. This clause has broadened the scope of the Act in order to better safeguard the rights of e-consumers. As a result, customers can now bring a lawsuit against e-commerce websites that violate their rights. Lawmakers have incorporated new technological concepts into the new Act, such as product liability, which states that if a consumer purchases goods or services and suffers damages to himself or his property as a result of the product or inefficiency of the service, the manufacturer or service provider, whichever is applicable, must compensate the consumer. This Act also includes terms like product liability action and product maker. A new authority, Central Consumer Protection Authority, which I'll refer to as CCPA hereafter, has been introduced to this Act to protect consumers from misleading ads and unfair trade practices that are harmful to the public interest at large. And with the goal of promoting, preserving, and enforcing consumer rights, the CCPA is addressed in Chapter 3. Various functions are provided. Now, because of the original Act lacked provisions pertaining to consumer concerns, lawmakers included provisions such as who to address grievances to, what the status of previous grievances, and how to settle grievances quickly. Now, may I just briefly give you the key highlights of the Consumers Protection Act? I need not spend much time on this. It includes the following: e-transactions. The concept of consumer has been broadened in the new Act. It now covers offline and online transactions, on electronic means, teleshopping, direct sales, or multi-level marketing. The term consumer now also includes any person who purchases any product or service. Then there is enhancement of pecuniary jurisdiction. Under the new Act, the amended pecuniary limits have been fixed. The district platform will now have to resolve grievances where the amount of products or services charged does not exceed 10 million. Where the such value exceeds 10 million rupees but does not exceed 100 million, the state commission may enter into disputes. And so far as the national commission is concerned, the jurisdiction if it exceeds 100 million. Then there is a procedure for e-filing of the complaints. There is an establishment of a e-Central Consumer Protection Authority, which the Act recommends the establishment of this authority, which is a regulatory authority with a strong enforcement powers. An investigative wing led by a Director General is accessible to the CCPA, which can perform and undertake investigation into breaches of consumer law. So these are new facets of the new Act. Now, broad powers have been given to the CCPA to take suo motu actions, recall products, order refund of the price of goods, services, cancel licenses, and file class action suits if more than one person is affected by a complaint. Then penalties for misleading advertisements and the procedure therein are provided. The penalties are quite heavy. Unfair trade practices is prescribed. Now, a specific broad concept of unfair trade practices enforced by the new Act, which also requires the exchange of sensitive personal information provided by the consumer, unless such disclosure is made in compliance with some other regulation. There is a provision for alternative dispute resolution. Now, I won't go into the discussion on the old versus new Act. It will take some time. So I'll skip that and then straight away go to the challenges which we face with the new Act in force. The new Act and its implementation is not without a fair share of challenges. The following are the archetypal ones and not the structural and infrastructural ones that usually plague the whole judicial system and its functioning, such as lack of adequate courts, personal paperwork involved, systemic delay. But the problems are to promote, safeguard, and develop consumer rights. The CCPA has been created with its headquarters in the national capital, while the government will settle issues at the regional centers. Violation of consumer rights, unfair trade practices, and misleading advertisements are being regulated by the CCPA. The role of upholding and improving this authority, that is the CCPA, will be committed to the government, and its consequences for the 2019 Act will definitely be very relevant. There is, however, less clarity as to how this authority and its role related to investigations and inquiries will function. Also, considering the investigation wing and the search and seizure functions, there is an overlap with the position of the Director General. The authority is permitted to issue guidance, order the recall of products, order refund of price, and penalize erring manufacturers, suppliers, service providers, and or endorsers. However, interestingly, it is only before the National Commission that appeals pertaining to such orders can be heard. The conditions by the fulfillment of which such cases can be treated by the National Commission are also uncertain. It is also uncertain if, due to a shift in pecuniary authority and jurisdiction, current cases will be asked or allowed to be moved. There is, however, speculation that only new cases will fall under the new jurisdiction. It is also necessary to examine the scope of the authority and power granted to CCPA in matters of investigation leading to product recall or penalization of manufacturers. Due to lack of accountability and appeals to be heard only by the National Commission, CCPA orders have the ability of normalizing the prejudice against producers. Additionally, there is little or no remedy to the victims of product recalls, which not only damage the financial position of such companies, but also impairs its reputation among the consumers for a long period of time. Another big challenge concerns the issue of liability of legal professionals for negligence and deficiency of services that fell within the scope of Consumer Protection Act 2019, given its wider definition of services. The service of lawyers was, however, clarified by Consumer Affairs Minister to be kept outside the purview of the Consumer Protection Act 2019 after facing much skepticism and backlash from the legal community and its representative collectives. Several provisions in other laws and acts and previous attempts to make laws acts such as Legal Practitioners Fees Act, Advocates Act 1961, the Draft Legal Practitioners Maintenance of Standards in Professions Protecting the Interests of Clients Act 2010 have either met a similar fate or have remained toothless. Thus, consumer protection doesn't really provide protection to consumer legal services. The most crucial point of contention is the question that whether the client of a lawyer or a law firm is a consumer or not, and whether the consumer fora is the right place to serve the purpose of providing remedies to victims of legal service deficiency without jeopardizing the sanctity and privity of a lawyer-client relationship, conflict of interest, and public policy. In India, the concept of one's kartavya, duty towards the nation building, is well established since ancient times. In recent environment, with the rising discourse around the sanctity of citizens' rights, the importance of duty is being neglected. As one of the judges had said, when you talk about rights, you should also speak about duties. While rights are being celebrated, duties are forgotten. And hence, realization of consumer responsibility towards ensuring protection of their own interests along with development of conscious consumerism is the essence of consumer protection. Unfortunately, the new act does not lay down consumer responsibilities exclusively, although it can be inferred from the intent of the lawmakers and through judiciary. It is necessary to uphold or recognize the significance of consumer responsibility in the legislation, as laws of a state play a parental role in the life of citizens and highly influence their decision making. Some of the suggestions which can be made, these are just suggestions and nothing to do. The law will progress, much will be written on this, but it can be the CCPA, its ambit and functioning is a bit of gray area in its current avatar. There is an increased need for elaborating the same. Specifically, the CCPA's roles concerning investigation and inquiries, the search and seizure operations needs to be outlined. Given that the CCPA has more teeth in certain crucial matters, such as issuing guidance to producers, companies, in the case of product recalls appeals, the CCPA should be made increasingly approachable in its truest sense. It is still early days for an authority of such nature to take shape, but surely some elaboration and template development can be done. And I'm sure as the days progress, much will be written on this and things will be set right. Now, There is no not a personal service because it is not an integral part of justice delivery system and has a relationship with court of law along with the client. Second, the duty of legal officers towards law essentially means that lawyers are nothing but officers of the court who have a duty to assist the court and not to act as a mouthpiece of the client. This, however, this cannot neglect the fact that lawyers are obliged to provide sufficient services to the client, and deficiency in such services cannot be excused by the law. Thus, one plausible way to overcome the issue in the new act is to include, maybe this is my opinion, but this will be considered by the legislature or by the judiciary. Furthermore, it is the duty of the citizens to question the applicability of the existing laws and to indulge more in negotiations. They should express their opinions, and that is how the law will progress. One important aspect is spreading awareness regarding the new law. Now, the rights and duties of a consumer flow from each other, along with demanding and exercising rights. The onus is on the consumers to follow duties which the new act requires. Exercising duties may include, besides awareness, filing complaints, class action suits, indulging in activism to ensure that rights are safeguarded by the institution in place. It would also be more prudent if the lawmakers can explicitly mention consumer duties in the legislation. For example, the Jamaican government recognizes both rights and duties of the consumer and publishes these on their official website. The duties included by the Jamaican government highlight the responsibility to be aware, gather information, think independently, speak out, complain, be an ethical, conscious, responsible consumer, and to respect the environment. Furthermore, duties are not just to be explicitly mentioned, but imbibed and performed to make the best use of the protection available under a law. It is a responsibility of the lawmakers and the judicial system to make consumers aware and of the consumers to rightly uphold duties first and then indulge in activism for the rights proclaimed in the Act. To conclude, I'll just say that the consumer protection is a critical aspect of a vibrant and inclusive economy. As the consumer landscape continues to evolve, we must be proactive in addressing the challenges that arise. By adopting a multifaceted approach that includes consumer education, regulatory reforms, effective enforcement, and alternative disputes resolution, we can create a more robust and effective consumer protection framework. I really appreciate the various programs which have been undertaken by the society, and especially this one-day international conference on such an important topic which is growing, which will grow, and which is going to evolve over the period of time. The challenges have to be overcome, and I'm sure they will be overcome as the time progresses. Thank you so much for inviting me. Thank you for being so patient. God bless you.
Thank you very much, Honorable Justice Makran Karnik, sir, for your insightful and inspiring address. Your esteemed presence has indeed glorified the event and added a vibrancy to our conference. We look forward for many more moments with you, sir.
Thank you so much.
Education is considered as a service for the consumers. Distinguished dignitaries and participants, the president of today's inaugural function is well known as an educationalist who has been instrumental in advancing women's education, who are the key consumers of any nation. This is our very own Honorable Mrs. Abida P. Inamdar, President, MME NRC, and Vice President, MC Society today. I request Dr. Bharti Shelke to introduce Honorable Mrs. Abida P. Inamdar, President of MME NRC and Vice President, MC Society today. Over to you, madam.
Yeah, volume is off. Correct.
Good afternoon.
Thank you, madam. Good morning to one and all. There says there is no greater pillar of stability than a strong, free, and educated woman. I, Dr. Bharti Sheke, is honored today to introduce such a strengthful lady who is one of the major pillars of this campus. She is admirable, insightful, innovative, determined, compassionate, and whatnot. She is a great adapting to different environment, having enormous emotional intelligence. She takes responsibility, always fulfill it. She pushes equality and she observes respect seriously. Yes, I'm talking about none other than Honorable Mrs. Abeda P. Namdar, Madam, President MMERC and Vice President MC Society Pune and President of today's function. Honorable Mrs. Abeda P. Namdar, Madam, has keen interest in education, particularly in women's education. That's why she resigning central government service and she joined her husband for serving the society by establishing various education institutions. Today, Madam is a successful educator and active social worker. It is said that Sri Ratna Samam Ratnam. Madam goes parallel to this without saying. Madam has a very active participation in educational work. She has various responsibilities in a different organizations such as member advisory committee, National Commission for Minority Education Institutions, New Delhi. Senate member of University of Pune,
New Delhi.
Managing Trustee, Pune Women's Council, Member, Senate, Ramananda Tirth University, Nanded. Not only this, Honorable Madam was the General Secretary for National Council of Women in India from the 1999 to 2002 and represented India at Helsinki, Finland. In addition to this, recognizing her excellent service and contribution in the field of education, Government of Maharashtra has awarded her Savitribai Phule Award. Along this, all Honorable Madam has commendable work for the right of minorities. Madam has published two special handbooks for challenges being faced by the various minority educational institutions and schools. Moreover, Madam is very soon going to publish a special book Margadarshik Pustika for minority rights of professional colleges. With these few words, I welcome you, madam. Thank you very much.
Thank you very much, Bharti Shelke, Madam, for the introduction of the President of today's function, Honorable Mrs. Abida P. Namdar. I request now Honorable Mrs. Abida P. Namdar to deliver the presidential address. Over to you, Madam.
Yes. Thank you very much for such an introduction. The chief guest of today's function, the eminent personality, Honorable Justice Makarand Karnik, Judge High Court of Bombay at Goa, resource persons, Advocate Vilota from, and another resource person, Advocate Yuko from Nigeria, Africa, other dignitaries, international participants, the principal of AKK New Law Academy, the other teaching staff and non-teaching staff. Welcome to this 2 days international conference on Consumer Rights or Consumer Protection Rights Day. This is international seminar. That's why I say that everybody here, we are consumers. And particularly 50% of the population, women, they are also consumers because they take care of the household and many of the items they buy online, offline. As Justice Karnik just now he said, e-commerce is there and lot of things are happening because of that. Cyber security or cyber crimes are happening, laws have been made, but the implementation of laws and the time justice delayed is justice denied. So many things has to be done. 2 days, I think all you young people, all visionaries, you'll sit together, you'll discuss, and I'm sure you're going to find the solutions to all the challenges. And you will come out some positive reference, as he has already suggested some suggestions, and that can be implemented. It is always two ways. The government or anybody at international level also, they have to get the information, the feedback correctly, so that some amendments can be made in existing laws. And if the best practices are there, just he said that in Jamaica they are doing, so why not take those best practices and we can implement in India and also at international level. I feel in Consumer Protection Act or in production or distribution, as the economy says, honesty is required. The ethical values, business ethics has to be followed so that whatever production is happening, that is distributed properly and it is to go to the consumer at a right time, at right place, and it is not harmful. Particularly for kids, when we see that there is some adulteration in milk, that's not, it's not, I mean, it cannot be accepted, and it is against the humanity. And we all should feel that we have certain duties towards the humanity, towards the young, the kids, and also those who are elderly persons, those who are taking some medicines, where nowadays lot of news or references are coming, and we feel that something should be done, some act, some this thing has to be done, something, somebody should take care of those consumers. The consumer protection has to be taken by everybody. And as I also feel that as consumer, we should also be very, very vigilant, very conscious, and we should know what are our rights and duties. If something is wrong, we shouldn't say jane do or let it go. No, we should file our grievances, file our complaints properly, and follow it up and see to it that proper action is being taken. I hope with these words, the other dignitaries, they are going to speak. They are masters in their field. And of course, we are there. We have done for last 40 years in the field of education. And education, I feel it's a service to the society. It's not a business. Even under Constitution of India, it has been mentioned, it's a noble cause and it is a service to the society. So that should be taken as, and the Consumer Protection Act should is also applicable to education. We should give best education, modern education, and moral education to our youngsters so that they become the future policy makers, and all these things can be implemented in a proper way. Thank you for giving me the opportunity. Best of luck for everybody, and I hope for 2 days you'll have more knowledge and you will be more positive on this subject. Thank you very much.
Thank you very much, madam, for your eloquent speech. You rightly said that honesty and ethics are the key elements in serving the consumers. Our next segment of resource person is an international speaker, Advocate Carolina Reyes Vilota, former President FIDA and Member of Parliament, Colombia, South America. Advocate Carolina Vilota, through her advocacy, has immensely contributed towards the protection of various rights of the consumers. To know more about her credentials, I request Dr. Manisha Agarwal to introduce Advocate Carolina Reyes Vileta. Over to you, Manisha, madam.
Yes, thank you, ma'am. Good morning, everyone, and namaste. It is an indeed matter of extreme pride, privilege, and pleasure for me to introduce the resource person of today's international conference, Advocate Carolina Rios Vilota, former President, FIDA, and current Member of Parliament, Colombia, South America. Madam has experience in diplomatic negotiations, international law frameworks, and cross-cultural legal initiatives. Madam is a perfect combination of social activist, academician, and researcher. She is a successfully engaged in high-level discussion on gender equality, access to justice, and legal protection for marginalized groups. Madam has completed her master degree in public and private contract law and specialization in constitutional law. Madam is practicing as a legal label advisor and compliance officer in various renowned industries and colleges since 2011. Few of them are Ellen's Motor Essay, Industrial Almity Sias L Triple Essay, colleges SAS and Colombian Institute of Family Welfare. In addition to this, Madam has worked as a keynote speaker at National Health in the Workplace Day in Palmyra on the topic of inclusion of people with disabilities in the workplace. During successful career, Madam has appointed as a president of various organizations like International Federation of Women Lawyers and Meals on a Wheels. Presently, Madam is acting as a member of Parliament Colombia, South America. With this few words, let's welcome ma'am. Over to you, ma'am.
Okay.
Thank you.
Welcome, welcome, ma'am.
Thank you very much, Manish Agarwal, madam, to introduce Advocate Carolina Rios Velota. I request now Advocate Carolina Rios Velota to enlighten the participants and share her expertise on the topic of today's conference. Over to you, madam.
Thank you. Thank you so much. Do you hear me?
Yes,
clearly?
ma'am.
Okay. Thank you very much. I want to, well, we are so far away, so it made me very excited just to be here and just to see that room with all you people, paying attention to this very important matter. I want to thanks and give my greetings to Dr. Shahista Inandar. She invited me to this event because we are colleagues and we are members of FIDA International, the Federation of Women Lawyers. Actually, right now, I am from Colombia, South America, but I'm currently in New York in this moment. Right now, it's 1 a.m. in the morning here. But anyway, I made the commitment to be here with you in presence in this virtual event. And I'm very excited to talk about this topic. Thank you, Shahista. Thank you to this excellent panel that we have today. I have also my colleague from Nigeria that I know also. We have, I feel honored, to be able to hear from Honorable Mr. Josh Makaran Kamik, Honorable Mr. Avira Inandar. It was a delight to hear them. I think we have to use all that wisdom that they have. And well, my presence today is to be able to speak about the situation of consumer rights in Colombia. Well, in South America, but especially in Colombia, Colombia, I don't know if you heard a lot about us. We are very well known for our coffee, for our emeralds, and for many good things. I don't know if you know Shakira. I don't know, James Rodriguez, very known for football players and many things. And well, we as a developed country that we are struggling also to achieve many laws that protect our people, that protect, in this case, the consumers. We have a frame law that is actually no agent, like you have in India. You have agents law, you have agents history, and well, we admire that a lot. But for us in Colombia, we don't have all that developed. We are still very new in this rights of consumers. So what we can say for now about the laws is that we have 3 laws. Okay, let me see if I can share my presentation first, because I got excited and I forgot to show you what I prepared for as a presentation. Hold on, let me see. Can you see it? Can you confirm you see the presentation on the screen?
Yes, madam.
Okay.
Yes, madam.
Thank you. Okay, so, well, as I said before, in Colombia, consumer protection is governed by various laws and regulations aimed of guaranteeing consumer rights and regulating commercial activities. So the main frame law that we have is the Law 1480 of 2011. Also, that's not very old, but that's like the main law that we have about consumer rights. This law regulates consumer relations and establishes consumer rights such as protection against misleading advertising, the right to quality of product and service, and the ability to file complaints or claims. For example, if a consumer buys a mobile phone with a great offer or discount, but receive a product that is not the model that they were promised, Law 1480 states that they have the right to file a complaint or claim a solution such as refund on a product exchange. So we have already in our country, for the big companies, this happens more with big companies because with little and small companies, the right to refund or to exchange a product that we are not agree with, that we are not happy when we got it, is not really possible yet. You know, we can claim to very big companies of like mobile phones, like big companies like the automobile companies or things. But if you have like some things that are not, especially even in the e-commerce, it's going to be more difficult to get a refund or to change that product. Why? Because it's very new and we were used to, I mean, it was something cultural. I don't know if it's cultural or what, but we still have a lot to do in that matter, you know? So if you receive a product and you're not very happy, well, you have to make a big process so you can get what you want or you can get the refund that you want. We still are we don't have that very developed yet. We also have the law. Okay, let me change the slide. Okay. We also have the law 1266 of 2008. It's about personal data protection, right? So this personal data protection is something that is more developed in Colombia than the law of consumers. I mean, this is a right for the consumers, but in Colombia we have more developed this legislation because these ones regulate the protection of personal data, establishing the conditions under which company can collect, store, and use consumer data, right? So because big companies, or well, many companies in Colombia, they used to sell the database. So when they said if you get phone calls from a bank that is giving you the opportunity to have a credit card, but you don't even know how they got your data, right? So that's very punishable in Colombia, and they have to have your permit for you to call you. So we are more developed in that matter. For example, if a company collects customer email addresses during an online purchase to send promotion, it must obtain explicit consent from customer for the processing of their data. I mean, in Colombia, you must have the authorization of who the data belongs, because if you don't have that and you are a company, you are a legal business, you will be in trouble with that. You will be I don't know, well, not prosecutor, but you will have an administration process. Well, that's something that I will explain later, how we where those claims goes. Additionally, if the customer decides not to receive more emails, the company must allow them to opt out of receiving advertising in accordance with this law. So if you don't want to be called again, if you don't want to be reached out again, you have the right to say, okay, you need to erase my email address from your database. So that's something that is very more developed in Colombia. And we also have the decree 1377 of 2013, and it's how we regulate the treatment of that data. Establishing specific guidelines for handling personal information in the digital environment, and regulates the treatment of data on online platforms. For example, a user registers an online store to receive a discount, but does not want their data to be shared with third parties. This decree requires the company to offer a clear option for the user to opt out of sharing their data with other entities, and the company must respect that decision. Because that's something that happens a lot for us as consumers, like the lady
टाइम
Imandara
लिखे
said.
ना उसमें
Yes, we all are consumers, and we need to have the opportunity to eliminate our data from any others of these bases, because if not, well, uh, that information, that personal information, can go to a places that we don't want them to have it. No, so that's something very, very. I mean, for us in Colombia, the data, the personal treatment of our information has more is more sanctionable or punishable than the consumer rights for refunds or exchange product than that. So okay, so consumer protection has evolved significantly. Well, as you see, those laws are not very old. Adopting in the new recent decades new laws, right? And we have been trying to get in the same track on the globalization and the digitalization and market transformation. But because we are a country in develop, we are a little bit behind that. So consumers now face new risks and challenge that require more robust intervention and a more dynamic regulatory framework. Below that, we explore the main facets of consumer protections today and how governments, business, and organizations can address these challenges. Other thing that, what are the digital era? In this digital era that we're living, we have new risks and new opportunities also. So like I said before, e-commerce has grown spontaneously, opening new opportunities for consumers, but also bringing new risks. The collection of personal data, privacy on digital platforms, and protection against fraud are some of the key aspects that need to be addressed. Companies will be transparent about how they manage user information, while consumers need to be more aware of the risks associated with sharing data on digital platforms. Well, that's something that it happened a lot in Colombia. You must be very careful, because when you give data to a well, no, I don't want to say that like an illegal company, because you never looking to give your personal data to a illegal person or company or entity, but that could happen because you don't know where that information is going to go, right? And we have a big issue because sometimes this company, they sell those data to criminal organization. That's the truth. And now we have a very big issue in some of the main cities of Colombia, because this database goes to be managed by people in jail. And from jail, they call people to make extortions and to call them to, with that data that they have. So as consumers, well, I don't know how it's in India. We have different, of course, backgrounds, really different religion, different, cultural things. But for now in Colombia, we have to be very careful with that, because that's something that is happening a lot right now. What are the challenges? So we have protection of personal data and privacy. Another challenge that we have, electronic fraud and phishing. I was talking about that, and misleading advertising and aggressive sales methods. Misleading advertising is something that is the entity of the government of Colombia that manage this situation. Let me think of the word in English because I don't, well, in Colombia we speak Spanish, so I'm doing my best with my English. But let me tell you the name in English exactly of the entity of the state of Colombia that um, procedure everything about consumer protection. Is the Superintendence of Industry and Commerce. That's the entity that have to treat any complaint or any claim that a person present about what we're discussing today. It's not like a person want to put a claim and go to a judge. No. First is this entity that is going to do a procedure, and then is going to decide who has the right, and it will it's like it's not like a jurisdictional sentence. No, it's an administration decision that could go through a penalty in money or that even close the business. So we have that. I don't know if the act that you are implementing in India have to do something with this, but in Colombia we have that. If that doesn't work, you still have the opportunity to go to a regular judge to manage, this with a sue. You have to sue the company and everything, but before that, you have an administration procedure to claim for your rights as a consumer. Okay, so let me go back where I was going. Okay. Let me see. Okay, so as I was saying, there are misleading advertising is something that we pay a lot of attention in Colombia. And we have a lot of companies that been punished for giving misleading advertising, mostly in the matter of woman like makeup or things like that promise too much, and that's a lie. So this procedure, and there's big sanctions for these companies in money. So they mostly close because they can't pay for that. And that happens because those suits take a long time, many years to go through. And that's something that we have to work also, because when you put a claim, it's not like you're going to have it right away. It's going to take a few years before you know what is going to happen with your claim. It depends on what you're claiming or what is your disagreement with your products. But mostly right now, the procedures are very slow. So governments, because of that, governments must update the data protection law, such as General Data Protection Regulation, to adapt the technological advancement and establish control mechanisms and penalties for companies that violate these rights. Digital platforms must be more responsible in their business practices, and consumers must be educated about how to protect their personal information. So that's a big issue in Colombia. I know in South America too, because we are Colombia, Ecuador, Venezuela, Peru. We are very similar countries. We are very similar in culture and religion and many things. So we are going like most of the time we are in the same path in our law frames. So I think I can speak a little bit for them too, for our neighbors, especially for Ecuador and Venezuela. So about the responsible consumers. Modern consumers are increasingly concerned about the social and environmental impact of their purchases. Interest in ethical, sustainable, and responsible products is rising, prompting companies to adopt more transparent and sustainable practices. However, new challenges have arisen, such as greenwashing, that is the false appearance of sustainability, and the lack of clear information about the origin of the products. So now in Colombia, we have these big campaigns, so we reduce the environmental impact that we as human beings have in the world. So many companies try to promote or to advertise their products as very environmental sustainable. And many of the time that's not true. So because the consumer mind has changed also in Colombia. Now after the pandemic or during pandemic, the COVID pandemic, the government of Colombia did a lot of investment in campaigns for people in their house because we were locked in our houses, to promote that we know how to dispose of our garbage, not to buy so many plastic things, bottles and everything. And of course, now we are more sensitive about that. But some of these companies, they try to give ideas or to give promises in their products that are not true. So that's something that we are really working on. I don't know how it's in India, because, for example, I know India has more than 1,000 population, I think more than that, and we are only like 40 million people. So the difference is huge, right? In population. But anyway, we are trying to work very hard in that. And as a consumers, we are already have that sensitivity to know that we need some ethical decisions when we get products and service. So what are the challenges about this? Well, to have lack of transparency in supply chains, for example, if we think that we are buying something that is going to be biodegradable, I mean, like something that is going to be able to go to the earth again very easy, but it's not. That is going to, for plastic and or cotton board that we think that is going to last a little time, and that is going to last a long time to be degradable on the planet. Greenwashing and misleading marketing about sustainability also, and the difficulty in comparing responsible products. Well, so what is the way forward about this? We have to public policies that should encourage traceability in supply chains, imposing clear standards of sustainability. In addition, consumers should demand greater transparency and make informed decisions, backed in reliable certifications and labels to guarantee the sustainability of products. So, for example, in Colombia, for products in their houses, like we buy to eat every day, we are more conscious and we have more sensitivity that we need that supply chain have good practice. Good practice in what? That we know that this company has social security for the workers, that they have the environmental impact that they have is decreasing. So we have this certification as quality certifications that we are going to look in these products, so we as consumers can guarantee that we are buying a good supply chain product that rely or that is current with our sensitivity as consumers. So another topic is the protection and vulnerable consumers, because we are consumers are like on the market. It's not like we have there's some population like the elderly, the children, and people with disability, or those that are in poverty require a special protection in this market. So equal access to goods and services, to the removal of barriers and financial inclusion are key areas that need to be addressed as consumers too. So we have this population that are more vulnerable. So we have to keep that in mind also. What are the challenges about this? We have digital exclusion of vulnerable individuals, right? So the modernity of platforms, the modernity of e-commerce and all things, we can do it, right? But there's this population people in disabled or elderly people that they don't have the same opportunity to reach out those digital technology. So that's a vulnerability that we have in this as a consumers. Marketing practices target at vulnerable groups, right? So directly to specific groups that this practice can affect their rights. Limited access to basic service due to the lack of inclusive policies. So we lack in Colombia, we lack inclusive policies a lot in many things, right? But also in basic service, like, for example, access to water, access to electricity, and sometimes, well, those are policies for the government that has to be done, but that make those rights as consumers well that are not protected. What is a way forward about this? The design of protection policies that promote digital inclusion and access to basic services should be a priority. Companies must ensure that their products and services are accessible and not discriminatory. And governments must promote education and digital literacy among vulnerable groups. So, as you see, the people that are here with us in this event, you have sensitivity about consumers protection, right? So here, if you like, I'm gonna send this presentation so you can have it, the slices of all this presentation, so you can, if you want, you can get more involved in some of the things that I have said, because for this you need sensitivity. I'm a lawyer and I have a lot of sensitivity about human rights, right? So maybe this is an opportunity that you expand some of the concepts that you have as a consumer right. Well, other things is the need for a stricter regulation and supervision. As the market globalizes and consumers have access to products from different countries, consumers' protection must extend internationally. Laws and regulation must be harmonized to ensure the protection of consumer rights regardless of their geographic location. And that happens a lot now because in Colombia, some platforms are very popular. I don't know if you use it in India, but for example, we have a lot of people use a platform that is called Ali. That's huge in Asia. Alibaba, I think that's the name. But when you order something online from them, it's like you have no idea if you ever gonna receive what you ask for. So thus consumer protection should be international. It doesn't matter that you ask something from Colombia that is a country very remote, and you ask something from Asia, that shouldn't matter, you know. And for example, it's still happening for Amazon. For example, I know everybody knows Amazon because it's very known. It's very aggressive in the advertising, and when you ask for something in Colombia from the United States, from Amazon, there's a big percent of chance that you're gonna get it, right? But what happens is you when you get it, you are not satisfied. What can you do? You have to wait months, or maybe you won't be able to send it back. So this protection should be international because the war is very globalized. So what are the challenges about this? So we have the mismatch of regulation between different countries. So we have to have a law frame that also can think about more than the board that we have in our country. We also have weak jurisdiction and lack of law enforcement. So what can we do as a Colombian person to to ask for the law enforcement of a company that is in, I don't know, in Hong Kong or in China or very far away. So, and also another challenge is to international business evading local regulations. That happens a lot too, and I have a good example about it. I don't know if in India you have this platform for no taxi, no a regular taxi, but the platform that you ask for a Uber, right? So, but this company Uber got in Colombia, and well, it was a successful because the service that the traditional taxis used to give was very bad. So when Uber got to Colombia, well, I use Uber because it's very fast. The cars are very modern. They're very clean. They're very punctual, and you know where you're going in the app. But they don't pay taxes at the beginning. Now they pay taxes, but at the beginning they didn't pay taxes. So international business at the beginning try to avoid the payment or to accomplish of these local regulations. So it's not like we were gonna say, okay, no, Uber, go away from Colombia. We don't want you here. We need those platforms too, but they need to do all to be able to have all the regulations and to pay taxes and to do all those things, because we as customers, if they don't have those regulations, who I'm going to claim that I leave something in the car or the service that was very bad? There's not going to be a person to go and do that claim. So what is the way forward to this? It's essential for countries to collaborate to establish global regularity frameworks that address cross-border trade and consumer protection in a digital environment. Regulatory agencies must intensify their cooperation and coordinate efforts to protect consumers globally. I mean, this is a global or international effort that we have to do. So the future of consumer protection is innovation and continuous adaptation. It's a continuous adaptation because if we don't do a continuous adaptation, we are not going to achieve what we need, right? Hold on, let me go back to the main screen. And okay, so we have to innovate. And as consumers and as lawyers, I don't know if of the audience are lawyers, but that's what we have to do. As the lady in Mandar says, we have to, new people, young people have to sit down and talk about this that we have to do. So the future of consumer protection will depend on the ability to adapt quickly to technological and economic changes. Artificial intelligence, the Internet of Things, and automatization will bring new realities that challenge traditional forms of protection for consumers, right? Artificial intelligence right now is something that we don't even know how it's going to impact our life because it's very fast. It's very fast. And as consumers, we will be impacted by this and affected by this. So what are the challenge? That we have unethical use of artificial intelligence in products and price personalization. We have also the risk associated with the automatization of customer service. And that's something that bothers me a lot as consumer also, because sometimes you need to make a claim and you call to these companies and they have a chatbot and you never get to talk with a person and you don't feel like you are being listened. So that's something that's a consumer that we have to do a law frame that is more clear and that is more efficient for the protection of the consumer. And also we had the challenge of the inequality in access to emerging technologies. Well, that happened to us in Colombia because we are a country that is in develop. But I mean, we lack in many places of our country, we lack of that technology. And how a consumer is going to ask for the rights, it doesn't have the access to technology, right? So I don't know if that happens in India, but I bet in some of the places, mostly in the countryside, when it's more difficult to get this technology, to access to any kind of technology. So the rights of the consumers won't be considered or protected. So what is the way forward to address these challenges? Regulation must be created to promote the ethical use of emerging technologies, protect consumer privacy, and ensure that automatization does not generate exclusion. Additionally, continuous education about new technologies will be crucial for consumers to make informed decisions. What is a reflection that we can do about this matter? Today, more than ever, it's crucial for all of us to be aware of our rights as consumers and the importance of demanding that they are respected. Not only should business be transparent, but consumers must also educate themselves and act responsible in an increasingly globalized and digitalized world. It is essential that our voices are heard, that our rights are defended, and that everyone from governments to business work together for a fair and more equitable market. My message to you in this is a consumer protection is not only the responsibility of laws, but also each of us. As consumers, we have the power to demand a more transparent and responsible market. We must be aware of our decisions and demand ethical practices, both for business and governments. So I invite you to reflect on the importance of staying informed and making responsible decisions to contribute to a fair world for everyone. In Colombia, we work a lot in this matter. Every time is better, because people is more aware of their rights, but we still have a lot of work to do to be able to protect consumer rights. So that's like my insight of the matter. I hope this can give you a little bit of idea what is happening in Colombia. And we can make an approach, anytime that we can, so we can speak about maybe other topics also. I want to thanks again for this invitation. I am a constitutional specialist. I have a constitutional law title as a lawyer, but I have this. And for me, always constitution, because our constitution in Colombia is beautiful. It's not working always. It doesn't implement. It's not implemented all the way. But always my view of rights is a constitutional view. So I think that's what we have to do to be able to have consumer rights and protection rights that work. Okay, so thank you very much. And well, I'm gonna stay here listening to the rest of the of the speaker, so I can learn a little bit more about Nigeria and also about the other speaker from the University of Mumbai. Thank you so much for this invitation, and I'll appreciate you, all of you. Thank you. We are so far away, you know. We're so far away. This made me so happy to be here, you know.
Thanks.
I hope you understand me.
Definitely, madam.
Thank you.
Thanks, Advocate Carolina Reyes Villota, for your thoughtful content and truly insightful presentation relating to the international best practices for consumer protection. You also have rightly emphasized that certain challenges like digital exclusion of vulnerable groups need to be addressed by the respective governments, and that consumer protection shall be at international level. Thank you, madam. We look forward for many more moments with you, ma'am. It's an honor to be graced by the presence of a renowned speaker, that is Advocate Chioma Onyenu Chia Yuko, who is our next international speaker for the conference. I take immense pleasure to introduce Advocate Chioma Onyenu Chia Yuko, who is a lawyer having a long standing of 18 years of practice, and she is the principal of Zest Legal Consults, a law firm in Abuja, Nigeria. She is currently holding office as a chairperson of the International Federation of Women's Lawyers, FIDA, Nigeria, Abuja branch for the term 2024 to 2027. She is a past vice chair of the Nigerian Bar Association, Abuja branch, and chair of its Human Rights Committee from 2020 to 2022. Past publicity secretary, International Federation of Women's Lawyers, FIDA, Nigeria, Abuja branch from 2016 to 2019. Currently, publicity secretary of the College of Arbitrators, Nigeria, and member of the International Society of Family Lawyers. With a multidisciplinary practice focus, Chioma's niche covers family law, human rights, consumer protection, labor laws, arbitration, intellectual property, and growing interest, health and medical law. She also passionately represents women and children in seeking protection from abusive situations and actively promotes advocacy for the enforcement of Violence Against Persons Prohibition Act and other women and child laws towards combating sexual and gender-based violence. In 2018, she was a part of a small team of 4 that represented Nigerian CSOs in drafting and presenting a shadow report to the African Committee of Experts on Rights and Welfare of the Child in Bamako, Mali, Addis Ababa, and Ethiopia, and also established the Police Duty Solicitor Scheme unit for the NBA Abuja branch during her watch at the branch's vice chairperson and chair Human Rights Committee from 2020 to 2022. Advocate Chioma has presented many research papers in different international and national conferences. As a public enlightenment enthusiast, she frequently hosts family law entertaining posts, the Zest Family Law Clinic, across social media. Chioma belongs to the following organizations, that is, International Federation of Women Lawyers, FIDA, Nigerian Bar Association, College of Arbitration, and International Society for Family Lawyers. She also volunteers as a special marshal of the Federal Road Safety Corps, an eloquent and versatile speaker. When she is not lawyering or public speaking, she relaxes by dancing or spending time with family and friends. With these words, I welcome you, Advocate Chioma, to this international conference. I request Advocate Chioma to proceed with a talk on unfair trade practices in India and Nigeria, a comparative study on consumer laws in Asia and African continent. Over to you, Chioma, madam.
Thank you very much, Dr. Jacinta. Thank you. Can you all confirm that you can hear me?
Yes, ma'am.
Oh, awesome. So it is my pleasure to be on this panel this morning. It's about 6:30 a.m. at my end, so it's still very early in the morning, and I'm excited to be here. Before I go into presenting my paper, please permit me to express my profound appreciation, to a lady close to our heart, a dynamic lady and great academician, and the coordinator of the Consumer Advocacy Group, yes, Dr. Shahista Inamda. It appears she's not on this call. She had told me she'll be traveling, but yeah, I'm immensely grateful for this opportunity, the introduction to the forum. I do not take it for granted. And my gratitude also goes to the principal of MCE Society's AKK New Law Academy Pioneer. That's Mr. Principal there, Dr. Salim Sharikul. Nice to meet you, sir. It was nice speaking with you yesterday. Thank you very much.
Thank you.
And of course, thank you, sir. To the coordinators of this brilliant online international conference, especially the amiable Dr. Swati Shinde. Thank you. Thank you for this opportunity. So now we go into the paper presentation proper. So what I seek, the objective I seek for us to achieve with this presentation will be to compare unfair trade practices, the legal frameworks, and institutional mechanisms for consumer protection in India and Nigeria. And the scope will be in defining what unfair trade practices are, examples of such, and the importance of consumer protection. I imagine that the last speaker, Madam Caroline, may have done some justice in that regard, but I'll just browse through it all the same. And then also go into a comparative analysis of the legal framework and institutional mechanism for consumer protection in India and Nigeria. Then we'll also look at some of those impediments, those challenges, that affect or impede efficient and effective consumer protection. And of course, also take some recommendations on what can be done to improve things in that regard. And in defining unfair trade practices, I simply define it to denote diverse, deceptive, fraudulent, or unethical methods used by businesses to gain an unjust advantage over competitors or exploit their consumers. Some of those sharp practices, that's what they'll call it around here, some of those underhand tactics that businesses deploy to gain an advantage that is unlawful, an advantage that is unjust, an advantage that is unfair, over their competitors, and also take advantage of their consumers, to exploit them. There are those practices that create unfair advantages for businesses that will mislead consumers or unfairly manipulate or control the market, And it is not a menace that is peculiar to India or peculiar to Colombia or peculiar to Nigeria. It is a global phenomenon. It is a global menace, and unfortunately, the laws and the policies are not the same, globally. So it varies significantly across countries due to dynamics like legal frameworks, economic situations, and of course, culture, which also plays a role in, perception and how some of those laws and policies are framed. And then some of the ways that unfair trade practices will manifest will include the sale of defective or inferior or counterfeit products, unsafe products. Some people will know that the product that they are marketing, that what they are offering to the market is something that is a counterfeit, is something that is inferior, something that is fake, or something that is outrightly unsafe. You know, sometime in the past in Nigeria, there was this period when we had serious issues around fake drugs. A lot of people will import drugs or even just to manufacture them in unhygienic situations, and then they'll parcel those drugs. Some of them will be things that are not even drugs at all, but they'll pack them in capsules and sell to unsuspecting members of the public. Sometimes you'll go to a factory or you go to a home even, and then you see people bottling water in very dirty environments, and the water they are bottling is not even hygienic. Or some of them will bottle will pack maybe a chalk and pack it into a tablet as if it is a drug, and then people will take it and it's not able to cure their illnesses, or it will not perform whatever they had expected for that drug to perform on their bodies or to improve their health. So any of those kind of attitude, any of those kind of manipulations are unfair trade practices. And then it includes the deployment of exploitative or predatory pricing strategies by monopolies or market dominant brands, especially in essential sectors like telecommunications or security. You know, maybe sometimes because of the cost of investing in a particular industry, sometimes at the commencement of that business, the prices may be high, sometimes justifiably. But then you also find out that some people, because they know that they are the dominant brands in a particular sector, in a particular niche, in a particular line of business, they are the brands that people know, the people-facing brands. Or because they don't have, they enjoy some monopoly, they will price their products or their goods so exorbitantly, so unfairly, so unreasonably, such that they exploit or predate on the consumers. So that is an example of an unfair trade practice. The other will also be the placement of fraudulent or misleading advertisements to lure unsuspecting consumers. When you go to buy a product online, for example, you'd usually find a narrative as to, or a description of what that product is, what that product serves, its benefits, its maybe modifications, classifications, things like that. They'll just post those narratives. And then sometimes after you have bought that product, you will then realize that maybe instead of a size 32, it's actually a size 35. Or instead of a pure leather bag, it's actually a synthetic leather. Or instead of color blue, as was projected, it is a pale green. Whatever it is that is fraudulent, whatever it is that misleads the unsuspecting public, that a product or service advertises and then shortchanges the people to give them something different, that is unfair trade practice. Then the other will also include, the provision of obnoxious or unfair terms and conditions in consumer contracts. Oftentimes, when you're subscribing to a service or you're trying to purchase something online, you will find that they would include those terms and conditions that are usually so lengthy, that are usually so tiny, that you're not even able to read through to determine if you fully understand what those terms and conditions are saying. And sometimes, because they are trying to be sharp, because they're trying to because of their unfair practices, sometimes you may inadvertently subscribe and say yes, and you will not realize that there are some provisions, there are some clauses, some paragraphs in that contract that is obnoxious, that is unfair. And you know that when it comes to the law of contract, one of the abiding principles will be the principle of fairness. So some of those clauses that are unfair will amount to unfair trade practices. Then the other thing will be, why is consumer protection important? Why are we talking about it? Some of the parts of what I heard Madam Caroline talk about, was even, she even took it to the point of saying that consumer protection should be a global thing because the world has become global. We're buying things from everywhere, right? But even beyond, before we even get to the global part of things, consumer protection is important for so many reasons because it will help to protect consumers from exploitation. If you leave things to chance, those who think they are smart will continue to take advantage of unsuspecting members of the public. They will continue to take advantage of, vulnerable demographics who probably cannot read, or those who may not even have access to or easy access to justice to seek redress. So without regulations for consumer protection, it means that we'll be leaving people vulnerable to be exploited by those who indulge in unfair trade practices. Then it also helps to keep businesses accountable and in compliance with relevant regulations or laws. Without those laws, businesses will behave as they will. They will do the things they want to do. There was a time in Nigeria when they used to produce bread. Most bakeries were producing bread with what they call bromate. And at the time, many people didn't know that it was harmful. Many people didn't know that it had some serious health implications for people to consume bromate in the quantities they were consuming them in bread, which was almost a daily staple, if you know what I mean. But it took the regulators, NAFDAC, to come then to say, no, bromate is unsafe. It's not healthy for people to continue to consume it. So they had to start regulating bakeries to ensure that they don't use it in producing commercial breads. And because of those kind of regulations, because of those kind of laws to ensure consumer protection, that was how the businesses were held accountable, because they knew that if they do not comply, that their businesses will be shut down, or if they do not comply, they'll be liable for criminal or civil actions. They began to comply, and that was how a lot of people were saved from the health hazards of consuming bromate in the quantities that it was being used then harmfully. So it actually holds businesses accountable and compels them to comply with relevant regulations. Then it also prevents the stocking or selling of hazardous products, thereby improving public health and safety. And the example I just gave about bromate also applies. Another example I would give was about, I spoke about NAFDAC earlier. So NAFDAC is our national agency for food and drug administration. Now, there was a time when Nigeria was notorious, and maybe I'm sure some of you may have heard it even from India or from wherever other country you were at the time. Nigeria became so notorious then for sale of fake drugs, for sale of counterfeit drugs, and it took NAFDAC to clamp down on them seriously before they were able to curb it, before they were able to reduce that scourge. It killed a lot of people. People were not recovering from their ailments because they were taking counterfeit drugs. People were not recovering because they were taking fake drugs. People were not recovering because they were misbranding drugs. Maybe they will pick paracetamol. They will now brand it differently just so they could sell it higher. Those kind of things. So consumer protection policies, laws, regulations actually helps in preventing the sale of hazardous products and saving, improving public health and then safety. Then it also fosters fair competition and trust in the market, invariably improving economic stability. So because there are regulations, that is why businesses will be priced better. They know that you can't just sell, let's use an essential service, like telecommunications, for example. You know that if you left our telecommunication giants, maybe some of them will be pricing their data or their airtime at exorbitant rates that many people won't be able to afford. And because it is not a service you can easily improvise or easily procure except from the experts, one will be bound to just patronize them grudgingly. But because of these regulations, it then helps to ensure that they do not price exorbitantly, price unfairly. You know, it creates for healthy competition so that they can all compete, fairly in a market that will also be beneficial to consumers. Then, in looking at, comparing what obtains in India and what obtains in Nigeria as per the statutory framework, the laws you have and the laws we have here in Nigeria, what are those laws that are, relevant to the conversation of consumer protection? And the key statutory framework for consumer protection in India, from my research, will include the Consumer Protection Act of 2019. And, findings reveals that this act provides a more robust safeguard against unfair trade practices, including covering e-commerce and digital transactions, prescribing stricter penalties, and mandating the establishment of multi-tier mediation cells to enhance quicker resolution of consumer rights disputes. It replaced the previous Consumer Protection Act of India, significantly redefining consumer protection mechanism in India. And I find it impressive. I think it's laudable that that act made provisions for multi-tier mediation cells. At the first instance, I think that alternative dispute resolution is a good tool that should be deployed in cases of this nature, except for situations where they become quite criminal, of such, they become heinous, and then they need to be held accountable. But otherwise, sometimes the parties are able to settle amicably, and then it will be more, it's usually more expedited, it's more speedy, unlike having to go through the rungs of going to court, filing this and filing that. And then sometimes they're also able to retain relationship and things don't go sour, as against the adversarial nature of going to court and it is me against you, or she against him, or whatever it is. So, but when it is mediation, when it is any form of alternative dispute resolution outside of litigation, it allows for more cordial resolution that is a win-win for parties. So I was really impressed to read that that act makes provision for mediation cells. And I also like that it refers to a multi-tier. When I come to what obtains in Nigeria, you will see that though we have what may be perceived as a special court for consumer protection, it is not multi-tiered. It's just at the center. It's just at the federal level. So it's not, you don't find it across maybe the states, the federal government, the area councils, and that's not what we have here. So I found that really impressive about the Consumer Protection Act of 2019. Then there is the Competition Act of 2002, which replaced the Monopolies Restrictive Trade Practices Act of 1969. And something comes to mind. So while it may have taken quite a while for that to happen, the fact that it happened at all means that the Indian government is inclined to keeping its laws up to date. How do I say it? Be standing. How could I put that? Just best practices, evolving with the trends. So that's quite impressive, because you usually will find that in some other developing countries, most of these laws are not even there. And even where they are there, they are just recent developments. Our law in Nigeria is not as old as what you had. So the fact that you've had one that has been in usage, and then the opportunity to review it again, means that you're some miles ahead of Nigeria. So that's commendable, you know. Then it prohibits anti-competitive agreements and abuse of dominant position, and regulates combinations, you know, that may stifle competition. And that's very good. That's commendable. Then there is the Bureau of Indian Standards Act. I think that would be similar to what we have. We have the Standards Organization of Nigeria. You know, that the act that defines the standardization and certification of goods and products. And I think that's the act that established the Bureau of Indian Standards as the national standards body of India. And I understand it repealed and replaced the 1986 Bureau of Indian Standards Act. So it's interesting to read, and to see that there is quite a number of reviews, amendments that has happened within the consumer protection legal sector, so to speak, in India. It's not just a one-off. These three laws that I've mentioned have each been reviewed recently, and that's impressive. Then in Nigeria, we have what we call the Federal Competition and Consumer Protection Act. Now, this act came into effect in 2018, and it repealed the Consumer Protection Act Cap C-25 Laws of the Federation of 2004. So ours wasn't really a long law before this FCCPC came in, if you understand what I mean. So ours was initially a decree of the military government, and then soon after we got into civilian rule, then they started amending it, and currently the last amendment was in 2018. And by this latest amendment, it now became known as, before now it was only Consumer Protection Act. That was just what it was. But I think they now, after borrowing from best practices in other climes, in other jurisdictions, they now infused the competition element into it, to regulate fair competition in the market. So now it has become the Federal Competition and Consumer Protection Act of 2018. And it has a fairly comprehensive framework for consumer protection and also competition regulation, like I've mentioned. And it established both the Federal Competition and Consumer Protection Commission, and also established a Competition and Consumer Protection Tribunal, which is now like our special court for consumer protection. So, and it's essentially to develop and promote fair, efficient, and competitive markets in the Nigerian economy, and to facilitate access to citizens to safe products and secure the protection of rights for consumers in Nigeria and for related matters. Then we also have our Standards Organization of Nigeria Act. That is a 2015 act, and just like what you have in India, it regulates the standardization and control of products and their quality. That's what that is about. Then we also have the Advertising Regulatory Council of Nigeria Act. Now, one may say that the ARUCN Act is not really specific to consumer protection, but it is very relevant because it helps to regulate advertising, such that they ensure that they prevent misleading claims, including those on digital and social media platforms, It's not only for your billboards that you stand on the street, or maybe your radio jingles and TV adverts. No, including social media adverts. So where an advert is seen to be misleading, where an advert is seen to be fraudulent, where an advert is seen to be to even be obscene. Maybe the advert is such that it violates public policy or decorum. They generally just regulate adverts. But the relevance to the subject of conversation this morning to me is the fact that they regulate misleading claims. Those adverts that project misleading claims. And that's to that extent it is relevant to consumer protection. And then there is the National Agency for Food and Drug Administration and Control Act. So this is the law that established the NAFDAC I mentioned earlier. And it is a law that the NAFDAC that it established is an agency of government that regulates and controls the manufacture, importation, exportation, distribution, advertisement, sale and use of food, drugs, cosmetics, medical devices, packaged water, chemicals, and detergents. So it is what they regulate are those commodities that people would ingest as food or drugs, or some of those things that people will use on their bodies. Those are the things they regulate. And because of that act, which then established this agency of government, there has, Nigeria has achieved a lot of sanity in that, in food and drugs. It used to be very, very worrisome. It was a very worrisome situation before the advent of NAFDAC, and before NAFDAC, gathered its belts and set to work. It was a real fight, Then, beyond just the laws, we'll now also look at the institutional mechanisms. Yes, some of the laws I've mentioned established institutions, So we're now going to look at those institutions that are versed or that are mandated with consumer protection in India and then in Nigeria. And from my research, some of the critical institutions for protection of consumer rights in India are the National Consumer Disputes Redressal Commission. And I understand it is the apex body that is saddled with resolving consumer disputes in India. So that would be like maybe like a Supreme Court of sorts, when it comes to consumer protection. And like I had said earlier, I was really delighted. I was impressed to see that multi-tier level that India adopted in its consumer protection setup, because that is not what we have in Nigeria. It's just a one-stop shop in Nigeria, which is the FCCPC. And, as we go deeper down, you will understand the disadvantages of that. I know you can imagine some of them already. So, but I see that the NCDRC is the apex body. And then you have the Competition Commission of India, which was established under the Competition Act 2002, and then which regulates anti-competitive practices, safeguards consumer interests and promotes freedom of trade in India. So in Nigeria, we that will now be the FCCPC. That's the FCCPC. That's like our commission. This will now be similar to that. And then you have the Central Consumer Protection Authority, which enforces consumer rights and penalizes unfair trade practices. So what I don't really understand here now is whether the CCPA authority is like maybe the court of first instance before you escalate or appeal to the NCDRC. I don't know. I couldn't make that finding. If somebody will be kind to enlighten me on that after I'm done with my presentation, I'll be most grateful, because I like to learn just as I also share. Then in Nigeria, like I mentioned to you, we have the Federal Competition and Consumer Protection Commission. That is our FCCPC. Now, they enforce consumer rights and investigate unfair trade practices. They are regulatory in the sense that they prescribe rules, they prescribe regulations, they investigate, and then they also prosecute, but they are not the decision-making body, if you understand what I mean. They are a regulatory body. They are like a law enforcement body that is specific to consumer protection, but they are not a tribunal, they are not a court, they are not a panel, And then we have the CCPT, the Consumer Competition and Consumer Protection Tribunal. Now, our Competition and Consumer Protection Tribunal is what is a court. That is the one that adjudicates on cases or subjects within the FCCPA. So they don't do any investigation. They are just a court. Don't call the tribunal because they're a special court, So, but their own is to adjudicate when matters that border on consumer protection, on fair trade practices, competitions and all of those. Once any of those kind of matters come, theirs is to adjudicate. And they have equal standing with a high court. So in Nigeria, we have the multi-tier system, but not on consumer protection. No, we have it in the general adjudicating system, where you have the court, the high court, you have the court of appeal, and then you have the Supreme Court, being the highest court of the land. So the CCPT is in the same ranking with a high court. Once they reach a decision, that decision can only be appealed to a court of appeal. That's the high court cannot, they have coordinate jurisdiction with the high court, except that their mandate is specific, is narrow to consumer protection and competition matters. That's what it is. And then, we then have the National Agency for Food and Drug Administration and Control. I had mentioned them a number of times. They are one of those agencies of government in Nigeria that has, I'll say to a great deal, impacted the people, over the years. One of the past DGs of that agency, God rest her soul, Professor Dora Konyeli, gained worldwide fame. She was she worked hard. She made a lot of changes. She brought a lot of reforms in the drug and food control sector in Nigeria. But she's late now. So, and generally they're the administrative body that is tasked with regulating and controlling, whether it is the manufacturing or the importation or the exportation or distribution, just anything that has to do with food and drugs. NAFDAC regulates that, And then, yes, we have these institutions. We have the laws, being the statutes. Yet, we're not seeing the results we want to see. There are gaps. There are shortfalls. There are, things are not moving at the pace we want them to move. Why is that so? So we're now going to look at the challenges, some of the impediments to efficient and effective consumer protection. And my findings reveal that in India, one of the challenges is the volume of cases that go to the consumer courts. The consumer courts are inundated. They are weighed down with numerous cases. And this causes, undue delays and may frustrate people in seeking access to justice. Now, there is also poor awareness of consumer rights in rural communities. This is not something that is not unique to India. It's similar to what is happening in Nigeria. You may even be miles ahead of us, because in the case of Nigeria, since we have only one central tribunal, one central special court for consumer protection related matters, it then means that of the 36 states that we have in Nigeria, and then the over 700 local governments that we have, how can all of them, sometimes more than 12 hours apart, come to one court to, for adjudication over such matters? So it's a lot of people don't even know that there is any such thing. It's mostly those who are in the Federal Capital Territory who know about it, because that's where it is. Even amongst lawyers, there are some lawyers who don't know that we have a special court, a tribunal that deals with consumer protection in Nigeria. So I understand the poor awareness of consumer rights, particularly in rural communities, and then the fraudulent exploitation of e-commerce and digital platforms for unfair practices. Madam Caroline gave examples of certain e-commerce site. She gave a positive example of Amazon, and then gave a not so positive example of another e-platform that I don't want to mention. So, but all those fraudulent exploitations are some of the things that impede efficient and effective consumer protection. And in Nigeria, one of our greatest challenges is that there is poor awareness of those statutory and institutional frameworks. Some people don't know that they're entitled to redress in law. Some people don't know that the fact that there's even a law that protects them from some of those exploitations. They've never heard it before. And even if they don't know who to go to. Where do we go to? So it's not like you easily find these offices across, or that they have digital platforms where you can easily make a complaint and somebody responds and deals with your concerns or helps you get remedy. And then there is a deep-rooted culture of corruption in Nigeria over the years, and it has permeated many facets of our life. It has permeated many areas. Of course, things are getting better, particularly during the government of the immediate past president, Muhammad Buhari. He tried to drive a campaign against corruption, but somehow it's endemic. It's still there, and it affects every facet. It affects every sector. People always looking for how to cut corners, how to do sharp practices. So even sometimes amongst the regulators, you will still find them taking bribe. You will still find them, maybe certifying things that are not fit to be certified because somebody gave them money, or because they are related to somebody. So there is that deep-rooted culture of corruption. Is one of those things that is frustrating, efficient and effective consumer protection. Then we have a proliferation of counterfeit and substandard products in the market. I had mentioned it earlier. Things have improved. There is an improvement in that regard, but it used to be really, really bad. It used to be bad, but now things have greatly improved. NAFDAC has done a really good job. It's one of those agencies, like I'll say again, that has worked hard, that has been effective to a great extent in Nigeria. And then there is poor access to justice for low-income earners, for those in the rural communities, for vulnerable demographics. They do not know how to access justice when somebody sells them short. They order something and you deliver another, or they even buy it and take it home, and then something that is supposed to last maybe a week spoils within 24 hours. They don't know who to go to, so they just cry and wipe their tears. And then the bureaucratic hurdles, even where you know where to go to, By the time you go, they say, you write a letter today, you submit it today, you will come back next week, they will take it to that office, another office will take it to another office will take it to. And you know that justice delayed can really be justice denied. When it is that ground, slow grinding, you come again and again, after a while, you want to get on with your life. You want to do other things with yourself. You begin to ask yourself, what is the cost of this remedy I'm seeking? What is the cost of this redress I'm seeking? As against the cost of seeking it. So when the cost of seeking justice outweighs the justice you seek to find, what's the justification in looking for it anymore? So the bureaucratic hurdles that make access to justice really slow-paced and frustrating is one of those impediments. So from this analysis, some of the things I saw was that, the statutory framework and the institutional mechanism in India has greatly evolved over the years. I know that for those of you there, it may not be satisfactory yet, but if you look at where others are, if you're able to evaluate things, analyze them, compare, and see that you even have some good advantage over others, then maybe you'll be a little more grateful for what you have, But that's not to say that there is not room for improvement. Life is dynamic, life continues to evolve. So even on this subject, there is room for improvement. So, but overall, your mechanisms and framework has greatly evolved over the years, over decades actually. Unfortunately, in Nigeria, things are still relatively new, but a step at a time, we're taking the right steps in the right direction. And then both countries have established specialized bodies, like I have said, being the CCPA in India and then the FCCPC in Nigeria, to address unfair trade practices. And also, we both have some special courts to adjudicate over competition and consumer protection matters. But like I had also said earlier, yours is multi-tiered, which is very commendable, which is really, really commendable. Ours is not. Ours is just at the center. It is just like a one-stop, special court. And then India has a more robust enforcement mechanism, but Nigeria, we're getting at it. We'll someday get there, I think. And then Nigeria's enforcement mechanism is weak. I had mentioned the challenge of corruption, I've mentioned the challenge of poor awareness. I've talked about, I didn't talk about poor resources, because sometimes the other frustration is, even where a law has been made, where an entity of government have been set up, if it is not properly funded, there's nothing they can do. They're not able to create as much awareness as they should, as is necessary to give effect to their mandate. They're not able to procure certain necessaries that they need for their work. There are just a lot of things they're not able to do. So that's one of the challenges we have in Nigeria. And, it appears India is doing better in that regard. For example, I like that you even have this consumer protection advocacy network, and that you're going at this elaborate plan for an international conference on the subject. That's not something that is easily likely in Nigeria. It's not a front burner conversation, if you know what I mean. It's not. Yes, there are recent cases that are beginning to raise small awareness, but that's essentially on social media. For example, there was that case recently of a young lady who came online to, according to her, she said she came to review a product. It was a tomato paste, and in reviewing that tomato paste, she said the tomato paste was too sugary, that it kills people. And then by saying that, some people said she had that was scandalous what she said about that product. It could run the product out of business, and they went to it became messy, really, you know. But she felt entitled to making a review because she was a consumer who had maybe bought what she thought was a bad product, except that maybe she was not aware of the right channel to vent. She wasn't aware of the right procedure for her to get redress. So unfortunately, she being the hunter became the hunted, you know. So, but gradually awareness is, you know, it gradually, but very gradually. One of the other things I also observed personally was that there was a case of a parent who registered her daughter in school, and unfortunately, the daughter was diabetic. She had been diabetic over the years, for maybe about 3 or 4 years that she had been in that school, and she was always taking her insulin and all of those. But a certain day, the mother just got a call, and the child was sick, and it was a teacher calling her but telling her, please don't say I called you. The school didn't permit me to, but I just felt as a mother, I couldn't bear not telling you that this child was sick. And the mother went to school. Long story short, that child died. She was 13 years old. And after she died, while the police were investigating to see if it was a possible homicide, the mother chose to write to the Federal Competition and Consumer Protection Commission to say that the school had breached her consumer rights because she subscribed to the services of the school, both for the education of her daughter and also for the custody of the daughter within the period, because it was a dormitory, you know, where the students live in school. And the school said no. I'm sure they had never heard about consumer protection. It was novel to them. And they said, no, the police is already investigating it. If the police is investigating it, then I don't know what you mean about consumer protection rights. And they went to court to stop the FCCPC from investigating. So this woman commissions me to represent her. And I tell the court, you cannot restrain a lawful agency of government from performing its duty. Their roles are different, and both roles can go on at the same time. Because while what the mother is seeking through FCCPC is of a civil nature, what the police are looking at is a criminal matter. So she was entitled to redress, whether, both criminal, in pursuing a criminal case and also in pursuing a civil claim. So there is really poor awareness. A lot of people do not know, but gradually people are beginning to know, but more needs to happen also, particularly in the rural areas. And then it also appears that in India, the laws impose stricter penalties, including fines, and imprisonment for unfair trade practices. So, but here, though we have penalties for some of those offenses, but data is very scarce. We don't have a rich database from which one can say, okay, in this case, this was what happened. In that case, that was what happened. But it appears you have a richer database in India. So, in view of all of this, what recommendations do I have? The recommendations I bring are, I think it's important in India, particularly from my findings, due to the finding that the courts are usually inundated with too many cases, maybe they need to increase the number of consumer courts you have in India. I'm sure that, in fact, I think it's kind of a good thing that you have too many cases, because it means that there is awareness. It means that people know their rights. That's what it means. In Nigeria, we don't have too many cases. In fact, the court is that the CCPT is really trying to create awareness. It's trying to get people to bring their matters to that court. The court is not as busy as it has capacity to be. So, and I think that stems from poor awareness. So the fact that you even have heavy dockets, your dockets are heavy in the court there, means that your people are aware. So, but it may be about time that they increased the courts, the number of courts, so that they can reduce case backlog and also increase access to justice to persons whose consumer rights there's been an infraction. And then we need to leverage technology better for monitoring of digital and e-commerce platforms, and even for purposes of allowing access to persons who feel disgruntled about the services they have received. So like I said, when I spoke about the bureaucratic challenges of accessing justice, if we leverage technology, both in India and in Nigeria, it will expedite the process. It will open up channels. People from even maybe the hinterlands, people from the rural areas will be able to access, because network is going quite global and has reached even our interior communities, right? So it's important to leverage technology. And then we should strengthen rural awareness campaigns. Instead of all the campaigns that happen in the city center, just the same people hearing the same thing all the time. And we're just a fraction of the population of the country. We should begin to reach further into the rural communities so that more people know, and then more people are able to have their rights protected. And then it's also important that government funds these agencies or some of these structures. It's not just enough to make laws. It's not just enough to set up institutions that will regulate, that will administer. Those institutions must be funded, because if they're not funded, then they might as well, they will remain paralyzed and not be able to optimally function. And then it may also help to strengthen penalties for some of these infractions, because punishment is a serious deterrent. When people realize that the punishment for some of these offenses are dire, then it may deter more people from trying to, proceed on that path. Then we should also improve awareness of some sectoral consumer protection entities, because beyond just the FCCPC in Nigeria I mentioned, there are some sectoral entities that monitor fragments, little components of consumer protection. For example, we have the Central Bank of Nigeria that regulates financial infractions. You understand? Maybe where the services of a bank falls short of the regulations of CBN. If you make complaint to CBN, CBN can hold that bank accountable. So some of those intersectoral consumer protection entities, there needs to be more awareness of what they do, where they are, so that people know where to go to for what kind of infraction they have. And then, while commending this international online conference, it's important that we promote regional cooperation. It must continue to happen. This should happen a little bit more frequently, so that we can share best practices and also share resources. And then, as Madam Carolina has said, it's a global discourse, right? And because it's a global discourse, we can all share and learn and go together and improve consumer protection across the world. Thank you so much. Thank you so much. I want to reiterate my earlier thanks. I do not take this for granted. It's really been a delight, joining you in this conversation. So thank you to the Law Academy. Thank you to the principal, Dr. Salim. Thank you so much, sir. Thank you, Dr. Jacinta, Dr. Swati. Thank you. God bless you all.
Yes, Dr. Shioma. Uh,
Yes.
yes, thank you very much, Shioma ma'am. You have highlighted on various aspects on the consumer issues and the rights. You have forwarded your system network in this regard in a very well manner. See, I didn't, ma'am, just one question. I didn't understand or whether I have missed it. As you
आवाज
said,
नहीं आ रही इनकी.
as yes,
Sir, your
am I
voice
audible?
is not audible.
Now, now,
Yes, we are getting your voice.
is it?
Yes, yes, we are getting your voice.
Sorry.
We are getting your voice.
Continue.
Uh,
Shall I continue?
shall I continue?
Okay. Yes, please proceed.
Okay. Thank you, Advocate Chioma on Yenuchu Chia Yuko. Your well-researched comparative analysis of statutory consumer protection in India and Nigeria is highly commendable. As per your analysis, one common hurdle in both India and Nigeria is a poor awareness of statutory and institutional framework for consumer protection. Thank you once again, Advocate Chioma on Yenu Chia Yuko, for the information shared by you was indeed incredible. May I now request our Vice Principal, Dr. Atul Zarkar, to propose vote of thanks.
Thank you, madam. Whether I'm audible?
Over to you, sir.
Sorry. I thought the principal wanted to ask a question.
No, ma'am. It was just in regard with the FCCPA. Are you getting my voice, ma'am? Madam,
Yes, I can. Yes, I can hear you. I can hear you.
Madam, I appreciate the way you have delivered your lecture on this, or you express your views on the consumer protection and their rights. But somewhere in regard with the functioning of the FCCPA, as you have mentioned that the procedure is lacking in regard with the investigation, right?
Sorry, you said the procedure is lacking for
Lacking
investigation.
in regard with the investigation. So, ma'am, the question is that how it leads to a fair process in spite of branded it as a special court for the consumer rights, and as they have to deal with specifically the fair trade practices and issues in that regard. And most importantly, the awareness that is not sufficient, I think so. The state authorities, they must take certain stand, certain action. So is there any efforts taken on behalf of the state authorities like legislature to proceed further in regard with the further, what we can say, the development of or on consumer rights?
Okay, as at now, none that I'm aware of. I mean, I must speak frankly. But
Okay.
I think what this consciousness now may also do for me is that among other subjects I used to pick for public enlightenment, I'm going to be more deliberate to ensure that I speak more about consumer protection. Do you understand? So I think it's about time that civil society organizations lent their voice, because if we leave everything to government, then not much will be done. We all owe a responsibility, right? So I think it's about time that each of us in our little spaces begin to amplify the conversation so that more people are aware, and then more people will engage the process. Because if we don't fully engage the process, we may not be able to weigh the weaknesses. We won't be able. The reason why India can now say that their courts are inundated is because a lot of people are aware and a lot of people are engaging it. But we don't have many people in Nigeria engaging our tribunal. Do you understand? So we need to create more awareness so that people can engage the system, engage the structure, and see if it stands the test of time. and see where the weaknesses are and see what needs to improve.
Okay. Yes. Yes. Thank you. Thank you, ma'am.
Yeah.
Thank you.
Thank you very much.
Sorry, Principal Sir, your voice was not audible. We didn't know that you had to ask a question.
No issue. No issue, ma'am.
And may I
You
now
can
request
proceed.
our Vice Principal, Dr. Atul Zarkar, sir, to propose vote of thanks.
Thank you, ma'am. Whether I'm audible, ma'am?
Yes, sir.
Okay. Respected dignitaries, esteemed speakers, distinguished guests, and dear participants, good afternoon to you all. It's my profound privilege and honor to deliver the vote of thanks at the conclusion of this insightful and interesting international conference on new facets of consumer protection, challenges, and the way forward. At the outset, I extend my sincere appreciation to our Honorable Chief Guest, Justice Sri Makaranda Karnik, Judge, High Court of Bombay at Goa, for gracing this occasion and for sharing your profound insights. I also extend my deepest gratitude to President of today's function, Honorable Mrs. Abeda P. Namdar, President MME and RC, and Vice President MC Society Pune. A special thanks to our distinguished international resource person, Honorable Advocate Carolina Rio Villota, former President FIDA and Member of Parliament, Colombia, South America, and Advocate Chioma Uko, Chairperson FIDA, Abuja branch, and Principal Just Legal Consult, Nigeria, Africa. I would also like to express my special gratitude to our college management and our respected principal Dr. Salim Sheikh sir and our esteemed faculty members and non-teaching staff for their support and guidance. A special note of appreciation goes to our organizing committee, student volunteers, and technical team. Once again, thank you all for being a part of this remarkable event. Thank you.
Thank you, sir. We now have the national anthem. I request all, as a mark of respect, to stand for the national anthem.
मागे गाहे तव जय गाथा जननायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you all for joining in this today's international conference. We wind up now. Thanks once again.